American History 2 students, this is Mr. Bell coming back at you with another online lesson. Thank you so much for tuning in today. We are going to cover American History 1, 2.4, and 2.5. Most of this is civics review, which I know some of you need because your civics got cut short because of the pandemic last year. But I'm going to compound 2.4 and 2.5 together, much like I did 2.2 and 2.3. So this, even though it's covering two sections, this shouldn't be a long lesson. Make sure you're keeping up with your assignments online if you're in an online class, and please email me any questions or concerns to bsbell@clevelandcountyschools.org. Thank you so much. Let's get started with 2.4. So this is going to look at the debate on how the government should be set up and how it ultimately got set up. Now, it says the Federalist and Anti-Federalist debate. That's really all Unit 3 is about. So we're not going to get into that as heavy as this unit section title would imply. Let's review the three branches of government. The legislative, which is Congress, that's the House and the Senate. The executive, which is going to be the president, vice president, the White House, and of course the judicial, which is the Supreme Court. So over in the legislative branch, the Speaker of the House leads the House of Representatives, the Senate Majority Leader leads the Senate, and the Vice President can also preside over the Senate. Of course, we know about the President and Vice President at the White House. You have 9 justices on the Supreme Court, led by the Chief Justice. They are appointed by presidents and confirmed by the Senate. We have a system of checks and balances. Our goal is to make sure we have 3 co-equal branches of government. While the roles have shifted from time to time historically, we have been able to use the system of checks and balances to ensure that one branch doesn't become more powerful than the other. Although over the past few years, it appears that Congress has become weaker, whereas the executive and judicial branch have become stronger. The Judiciary Act of 1789, it says it establishes the authority of the Supreme Court. Now, this is incorrect. So let me explain what I mean. Article 3 of the Constitution is what gives the Supreme Court its power. So this is incorrect. Article 3 establishes the Supreme Court. The Judiciary Act of 1789 establishes lower federal court systems such as the Circuit Court of Appeals and District Court. Justices are appointed by the President to the Supreme Court. If there is an opening, then the President can make an appointment and send that appointment to the Senate for confirmation. They go through hearings, they're interviewed, they're grilled rather meticulously, and at the end, the Senate will hold a vote. It used to be 60 out of 100. In the President Trump era, that has been changed to 51 out of 100 senators to get a Supreme Court justice confirmed. So, Supreme Court justices serve for life or until they retire, so they serve a rather long time, usually 30 to 35 years. If you're a liberal president and there's an opening, you're going to appoint a liberal justice. If you're a conservative president and there's an opening, you're going to appoint a conservative justice. Federalism refers to the sharing of powers between the state and federal government. An easier way maybe to explain this in civics would be concurrent powers. In other words, powers both the state government and federal government have. The state government has the power to tax state income tax. So does the federal government. Federal income tax. That's an example of federalism or a concurrent power. On the other hand, not all powers are shared. Not all powers are concurrent. So the federal government has the power of the military, whereas state has the power of education. I'm not getting into the Federalists and Anti-Federalists here because that's all of Unit 3. I just want to say these are the first 2 political parties. For most of our history, we've been a 2-party system. And even if you go from the first 2 political parties, Federalists and Anti-Federalists, to the modern political parties, Democrat and Republican, the debate's always been who should have more power, the state or the federal government. Here, the Federalists argue the federal government. The Anti-Federalists argue the individual or the state government. And this is all up to your political preference then and now. Hamilton was the face of the Federalist Party. More on that in Unit 3. John Jay is the first Chief Justice of the Supreme Court. He's not the most consequential, but he's the first. Somebody like John Marshall, who comes after, has a lot more impact on the America we know. The Anti-Federalists, also known as the Democratic Republicans down the line, led by Thomas Jefferson, the governor of Virginia and author of the Declaration of Independence and future third president. So, Federalist and Anti-Federalist, how do they view the Constitution? So, Federalists are going to be loose interpreters of the Constitution. So, they believe in bending the rules, reading between the lines. Like, maybe the Constitution doesn't say directly we can do something, but it implies it. So, loose interpretation. Whereas Anti-Federalists or Democratic Republicans believe in strict interpretation, by the book constitutionalists. If it says we can do it, we can do it. If it says we can't do it, then we can't. If it doesn't say, then just assume that you can't do it. Now, Washington does identify as a Federalist. He's not a big believer in political parties, so he's one in name only, not really in action. So, the Constitution replaces the Articles of Confederation post-Shays' Rebellion. So the debate becomes, is this Constitution giving way too much power to the federal government? And the eventual agreement is, so to get the states that need to vote to ratify the Constitution to vote, the Federalists promised the Anti-Federalists the Bill of Rights, are the first 10 amendments to the Constitution, which are going to empower the citizen and the individual. That's it for the 2.4 section. So let's go to 2.5. This looks specifically at the Bill of Rights, are the first 10 amendments of the Constitution, and a few other things. So, originally there were 12 amendments, but they cut it down to 10. We know the First Amendment. This, if you could list out one amendment, this is probably the one you could most easily write out. Free speech, free press, freedom to assemble, petition, or protest the government. Now, free speech doesn't give you unlimited power to say anything you want to without consequences. For example, if a student wanted to use foul language toward me, wanted to use obscenities, could they be arrested for it? No. Could they be sent out and suspended? Yes. One of the most integral parts of the First Amendment is freedom of religion. However, the words freedom of religion never appear in the Bill of Rights, the U.S. Constitution, at all. Instead, you have the free exercise clause. You're free to practice any religion of your choosing, even if that's no religion at all. Added up with the establishment clause, the government can establish a national religion. So therefore, these two things are interpreted together to create freedom of religion, in America. The Second Amendment, very popular in the South, the right to bear arms. The debate has been not whether or not people should have guns in the modern era, but what type of guns they should have. The Third Amendment bans the quartering act. If there is a war on U.S. soil, you do not have to house soldiers or provide food or rations for them. The Fourth Amendment, which is a result of the writs of assistance, protects against unreasonable searches and seizures. They can't take your property without good reason, and they have to have a warrant from a judge to search you. The Fifth Amendment is the most loaded of the first 10 besides the first. So, protects against self-incrimination. If you're on trial, you don't have to testify against yourself. You don't have to take the stand. You can plead the Fifth. Eminent domain is your right to private property and protection over that property. Double jeopardy, you can't be charged for the same crime twice. So if you're, let's say you're not convicted of murder, you're found innocent, then 20 years later, come to find out you did commit that murder. If it's for the same murder, they can't charge you then. Now, if it's for somebody else's murder, you could definitely be charged. You get due process, so you're entitled to a fair trial by a jury of your peers. The Sixth Amendment protects the rights of the accused The 7th extends that to a civil case. So let's talk about that. This is your right to a trial in criminal proceedings, things like grand theft auto or felony drug possession. The 7th is your right to a trial in civil disputes. Let's think about divorce. Let's think about traffic tickets. Let's think about custody battles. Those are civil cases, property disputes. The 8th Amendment protects against cruel and unusual punishment or excessive bail. So if you steal something in America, the punishment, if you steal a candy bar, can't be to cut your hand off like it is in some nations under Sharia law. The 9th Amendment says that there are other rights besides the Bill of Rights, and the 10th protects state rights. So if this power is not given to the federal government, it's reserved for the state. We've went over democracy and republic in 1.2. Let's look at some of these other forms of government. Autocracy, the power rests in the hands of a single individual. Autocracy and dictatorships, pretty much going to be the exact same thing. So one person has absolute power. Now, monarchy may have one person, absolute monarchy, a king or queen have an absolute power, but it's passed down from a bloodline. Limited monarchy is what they have in England today, in which Queen Elizabeth II is more of a figurehead of the British than she is an actual ruler, with their prime minister and parliament making major decisions. Absolute monarchies are what you had in England before 1215 with the Magna Carta. Totalitarian is using the military as a police force to coerce your citizens to do things they otherwise wouldn't do. The most infamous version of a totalitarian government is the Third Reich, the Nazi Germany under Adolf Hitler. Oligarchy, the rich control. The oligarchy and aristocracy. Aristocracy is the government's controlled by the wealthy. That could be several wealthy people. That could be influence such as political donations. Oligarchy is just a few people that have power, and yes, they are usually wealthy. Theocracy is a government based on religion. Think of the Middle East, places like Iran under Sharia law, and you probably know anarchy means no government. That's going to be it for these Unit 2 video notes. Thank you so much. I hope that you will get something out of these, and email me if you have any questions. Have a great day.